Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, in today's video, we are going to discuss all the questions of CrPC which came in the exam paper of JHARKHAND Judicial Services from the year 2008 to 2018. I hope कि ये वीडियोस आपके लिए बड़ी यूजफुल रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही beneficial रहेगा. And अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. Next 41, there shall be no appeal by a convicted person where CJM imposes only a sentence of fine not exceeding 100 rupees. C is the answer. And where this is provided, regarding this, it is provided in section 376, but there is no mention for CJM. However, JMFC, so it falls in the category of same method of first class, so not exceeding 100 rupees. Next 42. Too many appeals or revision are bane to the Indian judicial system, involving as it does sterile expense and delay and fruitless chase of perfection. Justice Krishna Iyer made this observation in Sitaram versus State of UP. C is the answer. Next 43. In the case of Supreme Court observed, thus, we are unable to find any magic or charm in the ritual of a charge. It is substance of these provisions that count or not their out form. To hold otherwise is only to provide avenues or escape for the guilt and afford no protection to the innocent. The court made these observations in relation to alteration of charge. A is the answer. Where is the provision for alteration of charge? 216 CrPC. नेक्स्ट इज 44. विच ऑफ द फॉलोइंग ऑफेंसेस इज ट्रायबल समरीली. देखिए, समरी ट्रायल के बारे में कहाँ मेंशन किया गया है? इन सेक्शन 260. और उसमें क्या लिखा हुआ है कि जो समन्स केस हैं या फिर जो उसमें मेंशन किए गए हैं सेक्शन 260 में, तो उनको ही आप जो है समरी ट्रायल कर सकते हैं. तो थेफ्ट वेयर वैल्यू ऑफ प्रॉपर्टी स्टोलन डज नॉट एक्सीड ₹500. नहीं, देखिए यहाँ पर इसको कर दिया है डू नॉट एक्सीड 2000. तो इस ऑफेंस को आप जो है समरी ट्रायल कर सकते हो. यस, दिस इज करेक्ट. फिर लर्किंग हाउस ट्रेसपास, यहाँ पर लर्किंग हाउस ट्रेसपास में पनिशमेंट जो है 2 ईयर्स की है. तो यहाँ लिखा हुआ है मोर देन एक्सीडिंग 2 ईयर वाले जो है उसको आप नहीं कर सकते, तो इसको भी कर सकते हो. फिर असिस्टिंग इन द कंसीलमेंट ऑफ स्टोलन प्रॉपर्टी ऑफ द वैल्यू नॉट एक्सीडिंग 300 रुपीज़. यहाँ पर भी 2000 की प्रॉपर्टी है, तो इसको भी आप कर सकते हो. फिर रिसीविंग और रिटेनिंग स्टोलन प्रॉपर्टी अंडर सेक्शन 411 व्हेन द वैल्यू द प्रॉपर्टी डजंट एक्सीड 250 रुपीज़. तो उसको भी आप कर सकते हो, क्योंकि यहाँ पर भी क्या है 2000 रुपीज़ की लिमिट है. अगर 2000 रुपीज़ होगा या उससे अबव होगा तो उसको समरी ट्रायल नहीं कर पाएंगे. तो सभी कर सकते हैं समरी ट्रायल. तो ये मैं कहूँगा कि क्वेश्चन थोड़ा ठीक नहीं बनाया, ये सारे ही समरी ट्रायल हो सकते हैं. Next 45. The period of limitation prescribed for taking cognizance of the offence punishable with imprisonment up to 3 years is 3 years. Section 468 provides for the same about limitation for taking cognizance. If it is fine only offence, then it is 6 months. Imprisonment is up to 1 year, then it is 1 year. And it is from 1 to 3 year, then 3 year, and above 3 year, no limitation. Next 46. In which of the following cases the constitutional validity of section 433A CrPC was upheld? It was Ashok Kumar Golu versus Union of India. A is the answer. Next is 47. Which of the following is an interlocutory order for the purpose of revisional powers of High Court or Session Court? Order summoning witnesses, या फिर order of bail granted by magistrate, order rejecting the plea of the accused at the point which when accepted will conclude the particular proceeding, या फिर interlocutory order which are without jurisdiction and nullities. This is the one. D is the answer. Next 48. A is only charged with theft and it appears that he committed the offence of criminal breach of trust. In this context, which one of the following is correct? He may be acquitted, he may be convicted for theft only, or he may be convicted of criminal breach of trust. This is correct. C is the answer. And this is illustration B to section 221, where It is for doubtful charge. Next 49. Which of the following court can set aside or modify the condition imposed by magistrate when granting bail? High Court of Court of Session under Section 439 CrPC. It is correct. High Court under 482. No. Provision is mentioned in Section 439. So A is the answer. Next 50. An offence of bigamy punishable under Section 494 was committed by A in Patna. The place where A resided with his first wife B was Gaya, and the place where his first wife took up a permanent residence after the commission of the offence is Bhagalpur. The offence may be inquired into or tried by a court of competent jurisdiction at Patna, Bhagalpur, Gaya, if all of the above. All of the above, D is the answer. Exit 51. A magistrate has power to deal with urgent cases of apprehended danger or nuisance under Section 144 CrPC. B is the answer. Next 52. Which of the following magistrate have power to prohibit repetition or continuance of public nuisance? DM, SDM, judicial magistrate, executive magistrate duly empowered in this behalf. ये executive magistrates की power होती हैं, तो 124 C is the answer. And this is mentioned in section 143 CrPC. Next 53. Assertion. The provision for reviewing the decision of a criminal court are essential for the due protection of life and liberty. This is correct. They are based on the notion that judges and magistrates are not infallible. This is also correct. So both are correct. A is the answer. Next 54. Assertion. Subject to some exception, the provision of the CrPC are not applicable to tribal areas in undivided Assam. This is correct. These areas enjoy special status like state of Jammu Kashmir. No, it is not correct. So A is correct, R is false. C is the answer. Next 55. Reason for non-applicability of some of the provisions of CrPC to the state of Nagaland have been stated by the Supreme Court in. Next 56. Who can appoint a police officer as an assistant PP for the courts of magistrates? तो देखिए, जो पुलिस ऑफिसर को बनाना है क्या, असिस्टेंट पब्लिक प्रोसिक्यूटर, तो कौन कर सकता है, किसके पास पावर है, एसपी के पास या फिर सेशन जज के पास या फिर डिस्ट्रिक्ट मैजिस्ट्रेट के पास पावर है, तो सी इज द आंसर. कहाँ मेंशन किया गया है, इन सेक्शन 25 का सब सेक्शन 3 ऑफ CrPC. Next 57. Whom the following can be arrested without warrant by any magistrate? Any person committing offence within the local jurisdiction of such magistrate but not in his presence. No. Person committing offence anywhere but in his presence. No. Any person within local jurisdiction of whose arrest he is competent to issue a warrant. Yes, it is correct. C is the answer. Arrest by magistrate is mentioned via section 44 CrPC. Next 58. Now list 1 list 2 को मैच करना है. So special metropolitan magistrate is empowered to imprisonment up to 3 years. Yes. Chief metropolitan magistrate 7 years. Judicial magistrate second class 1 year. Assistant session judge, it is in up to 10 years and fine. So 3142. So this is 3142. D is the answer. This is section 2829 of CrPC. Next 59. Where 2 or more courts have taken cognizance on the same offence and a question arises as to which of them ought to inquire into or try the offence, the question shall be decided by, if the courts are subordinate to the same high court, then by that high court. It is correct. By the high court within local limits whose appellate criminal jurisdiction the accused resides. No. If the courts are subordinate to same high court, by that high court in consultation with the state government. No. If the courts are not subordinate to the same high court, by that court within the local limits whose appellate criminal jurisdiction the proceedings were first commenced. It is correct. So 1 and 4 are correct. C is the answer, and this is section 186 CrPC. Next 60. Assertion is power of the state to order cases to be tried in different session division is very limited. This is correct. Reason is that this extraordinary power is to be used when consideration of public justice justifies its exercise. This is also correct. And correct explanation, A is the answer. Next 37. Under section 37 CrPC, every person is bound to assist a magistrate or a police officer in the taking or preventing the escape of any other person whom such magistrate or police is authorized to arrest. It is correct. In the prevention or suppression of breach of peace, yes. Prevention of any injury attempted to committed to railway, yes. All of the above, D is the answer. Next 38. In a cognizable case under IPC, the police will have all the powers to investigate except the power to arrest without warrant, या फिर including the power of arrest without warrant. B is the answer. Case is cognizable case na. So definition of cognizable case is mentioned where? Section 2C of CrPC. Next 39. For the purpose of taking cognizance of an offence, what period of limitation is prescribed by the court for an offence carrying punishment not exceeding 1 year? So section 468 of CrPC mentions it. If the punishment is of fine only, then 6 months. If the imprisonment is up to 1 year, then it is 1 year, and from 1 to 3 year it is 3 year, and 3 and above no limitation. So not exceeding 1 year, it is 1 year. C is the answer. Next 40. What is the maximum period an executive magistrate may authorize the detention of an accused in custody? 7 days. C is the answer. Mentioned in section 167 itself. CrPC. Next 41. Who is not entitled to any maintenance under chapter 9 of CrPC? Divorced wife, yes. Entitled hai. Judicially separated wife, yes. Illegitimate child, yes. Physically and mentally able adult son. It is mentioned able son. So he's not how able and also adult. Adult means major, not a kid, not a child. So he's not entitled. So D is the answer. And where is the provision? Section 125 CrPC. Next 42. How long a warrant of arrest shall remain in force? Until executed or cancelled. D is the answer. And where this is mentioned? It is mentioned in section 70 CrPC. Next 43. What is the time limit prescribed within which claims and objection to attachment to be made under CrPC? 6 months. A is the answer. Mentioned where? In section 85 subsection 2. Next 44. Under what appropriate section a magistrate may issue an order of injunction? Under section 142. B is the answer. Next 45. Under what section of CrPC magistrate may direct local investigation? Section 139. A is the answer. Next 46. Whom the following may ask for security for keeping peace on conviction? It is either court of session or judicial magistrate first class. D is the answer. And I have also given you a chart in my previous video. If you have noticed it or not, I don't know. So just write section 106, 107, 108, 109, 110. So on conviction, other cases, seditious matter, suspected person and habitual offender. So court of session or judicial magistrate first class. Then EM, executive magistrate, EM. How many years? For 3 year, 1 year, 1 year, 1 year, 3 year. Okay. So whenever you're going in the exam, just write it down this small chart on the rough space. In every exam, you will get a rough space in the paper itself. So as soon as you get the paper, just write it down over there so that you can just remember it in the paper. This one question will always come from this chart. Next is 47. What is the maximum period under section 110 CrPC for furnishing security prescribed for keeping good behavior? It is 3 years. D is the answer. You can see this 2 questions came from that chart only. Small chart. You will hardly take 10 seconds to make it. Next is 48. A confession made under section 164 of CrPC can be recorded by magistrate during the course of, देखिए कब होती है इन्वेस्टिगेशन में, तो ट्रायल में नहीं होगा, ट्रायल और इन्वेस्टिगेशन नो, इन्वेस्टिगेशन बट बिफोर द कमेंसमेंट ऑफ इंक्वायरी और ट्रायल. डी इसका करेक्ट रहेगा। देखिए बी भी ठीक है बट बी इज इनकम्प्लीट, डी इज परफेक्ट, डी इज द आंसर। सेक्शन बताइए दिया 164। Next 49, trial commences in warrant case instituted on police report with the issuance of process against the accused person or with the submission of police report on framing of formal charge. Formal charge पे ही तो होगा। C is the answer. Next 50, which of the following statement need not be signed by the maker? Statement under section 161 given to police is not required to be signed. C is the answer. Next 51, under which section of law magistrate has power to issue commission for examination of witness in prison? That is section 271B is the answer. Next 52, under which section of law the court has provision to direct tender of pardon to the accused before pronouncement of judgment? That is section 306. That is section 307B is the answer. 306 is tender pardon to accomplice. Always remember this thing. And this is the power of magistrate, and 307 is the power of court of session. Mind this as well. Okay. Next 53, if question asked to witness to any matter relevant to the matter in issue and answer given by witness to such question will criminate him, then the witness shall be compelled to answer such question if he shall not be compelled. The witness can be compelled to answer such question. A is the answer. And where this is provided, it is provided under section 148 of Evidence Act. Next 21, a magistrate has the power to direct the police to investigate into an offence in CrPC. That is 156(3) CrPC. A is the answer. Next 22, under the scheme of criminal procedure code, non-cognizable offense are private wrongs. A is the answer. And non-cognizable offense is defined where? In section 2L of CrPC. Next 23, under section 159 CrPC, the magistrate has the power to depute any magistrate subordinate to him to hold a preliminary inquiry or direct investigation by the police. He can do either. C is the answer. Next 24, under section 167 CrPC, the nature of custody can be altered from judicial to police custody and vice versa. This alteration can be done during the first 7 days or first 15, 14, 10. First 15 days. B is the answer. Next 25, cognizance of offense of defamation under chapter 21 IPC can be taken on a complaint made by an agreed person, on a police report or suo motu. On a complaint made by an agreed person. A is the answer, because it is a non-cognizable case and a complaint case. And this is mentioned in section 199 CrPC. Next 26, joint trial of several persons is permissible under section 223 CrPC. D is the answer. Next 27, rule entry for acquit or entry for commit. See, they have made a mistake here. This is autrophoes. Acquit and autrophoes. Convict. As I mentioned earlier, there are several spelling mistakes in the paper. So it is contained in section 300. B is the answer. Next 28, in which of the following cases the Supreme Court held that High Court cannot directly entertain bail application of quota accused without its refusal by a special court? It is State of Gujarat versus Salim Bhai Abdul Ghaffar Sheikh. B is the answer. It might have been in recent cases. Next 29, a legal remembrance cannot be made ex officio public prosecutor. It was held in case of, none of the case was from here, so answer was none of the above. D is the answer. See, there was a decision of Calcutta High Court in case of V.K. Godhwani versus State and others. And this is remembrancer, not remembrances. Next 30, urgent case of nuisance and apprehended danger falls under section 144 CrPC. B is the answer. S31, when warrant also cannot be executed, the court may proceed under the substituted proceedings in section 82 and 83 CRPC. B is the answer. S32, plea bargaining, a new chapter was added in CRPC by Criminal Law Amendment of 2005, is contained in chapter is 21A and section is 265A to 265L. C is the answer. Next 33, a magistrate may under section 252 or section 255 CRPC convict the accused of any offence triable under chapter 20 of CRPC. B is the answer. Next 34, in which of the following cases the Supreme Court held that FIR was not substantive evidence and could only be used to corroborate its maker? It was held in C. Magesh versus State of Karnataka. D is the answer. This is a repeat question. Next 35, in summons case and inquiries, memorandum is the only record of witness accused statement of evidence. Evidence. C is the answer. Next 36, if the accused is not acquitted under the section 232 CRPC, then the court calls upon him to enter on his defense. A is the answer. Next 36, the power of Supreme Court to transfer cases and appeals from one High Court to another High Court can be exercised on application by Attorney General of India. B is the answer. It is mentioned in section 406 CRPC. Next 37, which of the following section of CPC is related with legal aid to accused at state expenses? That is 304. A is the answer. Next 38, inquiry under CRPC is conducted by magistrate. A is the answer. And court as well. So either A or B. D is the answer. Next 39, application for anticipatory bail may be made before High Court or Court of Session. Both A and B. This also should be A or B. D is the answer. There is a provision for anticipatory bail in CRPC 438. Next 40, which of the following court can try summarily the offence mentioned in section 260? CGM, Metropolitan Magistrate, any magistrate of first class, specially empowered by High Court. All of the above. D is the answer, where this is mentioned in section 260 itself. Next 41, the procedure for summary trial is provided in which of the following section of CRPC? 260 to 265. C is the answer. Next 42, under which section of CRPC inherent powers can be exercised by the High Court? Section 482. A is the answer. Next is 43, who among the following cannot claim maintenance under section 125(4) of CRPC? A wife lives in adultery? No. Wife living by mutual consent? No. So both cannot. So C is the answer. Next 44, which of the following is not correctly matched? Arrest by private person, it is mentioned in section 43. Arrest by magistrate 44. Housemaid 46. By police without warrant 41. So which is wrong? A. A is the answer. Next 45, private person may arrest any person who in his presence commits a non-bailable and cognizable offence. So D is the answer. Again, section is 43 CRPC. Next 46, the maximum period for which a magistrate may send the arrested person in police custody is 15 days, and that is only first 15 days from date of arrest. So B is the, from date of presence before the magistrate. So B is the answer. Next 47, which of the following offences is not compoundable? So 323 is simple hurt. 334, voluntary causing hurt on provocation. This is also compoundable. 307, attempt to murder, not compoundable. 379, theft, compoundable. So C is the answer. Compounding of offences is mentioned where? Section 320 CrPC. As 48, warrant case means a case relating to an offence punishable with up to 1 year imprisonment. If more than 2 year imprisonment, C is the answer, where it is defined in section 2X of CrPC. Next 49, the case of Muhammad Ahmed Khan vs. Shahbano Begum is related with maintenance. B is the answer. And where is the provision? Section 125 CrPC. Next 50, which of the following section of CrPC provides for confirmation? This is confirmation by High Court of an order of death sentence given by the Session Court. That is section 366. A is the answer. And it is very controversial question. Several states give the answer of 368, several states give the answer of 366. But the power of confirmation is in 368, and when Court of Session gives the order sentence of death, it submits this order before a High Court, and submission of that order before High Court is provided in section 366. So kindly understand this thing, okay? So you can answer it properly. A is the answer. Next 51, which of the following section of CrPC is related with security of good behavior from suspected person? That is 109B is the answer. I always mention, and I always talks about a small chart. Mention section here 106, 107, 108, 109, 110. So put the provisions here on conviction, other cases, seditious 108, suspected 109, and habitual offender 110. And what is the maximum period for security? 3 year, 1 year, 1 year, 3 year. And who can take? Court of Session, JMFC, MM, and here EM, 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 EM. So whenever you go in the exam, whenever you get the paper, just write this chart on your rough page. Next 52, which of the following is the content of charge? Name of the offence, law which the offence is said to have been committed? Yes, both. C is the answer. Contents of charge is provided where? Section 211 CrPC. Next 53, who framed the charge? Charge is framed by court. D is the answer. Next 54, which of the following section of CrPC is related with withdrawal of prosecution? Section 321. B is the answer. What is 320? Compounding of offences. Just mentioned it. Next 55, in summary trial, the maximum punishment is 3 months. A is the answer. Where this is mentioned? It is mentioned in section 262 of CrPC, and particularly in subsection 2. Next 36, the CrPC was last amended on, they are asking about the amendments. So the last amendment which came in 2018 came on 11th August 2018. C is the answer. And this was the date of notification. However, it gave a retrospective effect from the date 21st April 2018. Next 37, CrPC contains 484 sections. D is the answer. This is easy question. How? 482 is the inherent powers of the High Court, and all sections are below that 482. Only one option is there. Next 38, FIR can be quashed by a High Court on the ground parties having arrived at settlement no heinous offence was committed according to the charge sheet. It is correct. The parties having arrived at that settlement and heinous offence was committed, no. Serious financial fraud was committed, no. Without any ground, no. A can be the answer. And under what provision? Under section 482, inherent power of High Court. And 39, a magistrate may dispense with personal attendance of accused under 205 CrPC. B is the answer. Next 40, if the evidence is available about a person who appears to have committed an offence but his name is not mentioned in the charge sheet as accused, his name can be added by judicial magistrate or session court, or cannot be added. A name can be added by the High Court, Supreme Court, no. Judicial magistrate or session court can add his name. A is the answer. Under which provision? Section 319 CrPC. Next, 41. Which of the following statement is correct? A police officer has the power to require attendance of a witness under the age of 15 years before himself. No. He cannot ask for attendance of a person below 15 years and above 65 years. Or woman. This is the attendance of woman, also wrong. 65 years or wrong. Does not have power to attendance who are mentally. This is correct. D is the answer. This is section 160 CrPC. Next, 42. When the injury or trial relates to an offence committed under section 376 CrPC, the inquiry or trial shall be concluded within the period of. Now, I would say this question is wrong. How? This is IPC, not CrPC. It is mentioned an offence committed under section 376 IPC, and such inquiry or trial shall be completed within 2 months after filing of charge sheet. It is mentioned in section 309 proviso. So I would say this question should have been deleted. Next, 43. Rule autrefois acquit and autrefois convict is contained in section 300. B is the answer. It relates to double jeopardy. Next, 44. Every person is under an obligation to give information about the commission of an offence to a nearest magistrate or police officer for offences under section 121 to 126 and other several sections of IPC, not CrPC. But this is mentioned in CrPC in section 39. So B can be the answer. Next, 45. Which section of CrPC involves the reciprocal arrangement to be made by the central government with the foreign governments through a treaty with regard to service of summons, warrants and judicial process? See, section 100 is search in closed place. Okay. 103 is magistrate may direct search in his presence. 105A are certain definitions relating to chapter 7A, which is a reciprocal arrangement. Okay. And 104A is just nothing. I would say these options are also not correct, not proper. How? They're asking about the section and there is no particular section mentioned this. However, there is only definition section of 105A, in which definition of contracting state is also mentioned in clause A of 105A. So I would say this question is not proper, but reference can be given to C. Next, 46. A woman can claim maintenance from her husband if she lives in adultery. No. If she refuses to live with her husband. No. If she lives separately by mutual consent. No. If she is neglected, then yes, she can claim. D is the answer under section 125 CrPC. This is 47. A magistrate can ignore the conclusion reached at by the investigating officer and apply his mind independently. Yes. Not ignore the conclusion. You have to ignore the conclusion reached by the IO and apply his mind independently only upon statement of witnesses recorded by the under any circumstance. Not ignore under any circumstance. No. So A is the answer. Next, 48. A statement made by any person to a police officer in the course of an investigation can be used for any purpose. या फिर cannot be used for any purpose except for the purpose of contradicting a witness. D is the answer. This is mentioned in section 162 CrPC. Next, 49. When the court of session passes a sentence of death, then the proceedings are submitted to the High Court and death sentence is executed. No. Proceedings are submitted to the High Court and death sentence is executed only after the confirmation by the High Court. Yes. So, in which provision you submit for confirmation under section 366, and power of High Court to confirm is provided in section 368 CrPC. Next, 50. Anticipatory bail is granted by High Court or Court of Session in anticipation of arrest in non-bailable cases. Yes. In bailable cases, no. Bailable है तो bail तो मिल ही जाएगी फिर. By passing a regular court which had to try offender, no. Ordinary circumstances, no. A is the answer. Provision in section 438 CrPC. Next 51. The maxim quando lex equilit aliqui concedit considere vedatur it sign quaere ipsa esse non potest is enshrined in section 482 CrPC. C is the answer. What it means? इतनी लंबी मैगजीम है ये, क्या मीनिंग है इसका? This is a Latin phrase. The meaning of it is whoever grant a thing is deemed also to grant that without which the grant itself would be of no effect. So friends, here we have discussed all the questions of CrPC which came in the exam paper of JHARKHAND Judicial Services from the year 2008 to 2018. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो उसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. तो काइंडली गिव अस अ सुपर थैंक्स. सो फ्रेंड्स, थैंक्स वेरी मच फॉर वॉचिंग दिस वीडियो. थैंक यू.